Number 4, the delay prejudiced the opposing party, undue expenses, loss of evidence, or in some other way. Number 5, attorney offered reasonable justification for non-compliance. In other words, an excuse as to why it's okay. Number 6, the delay caused significant problems of judicial administration. So in this case, the court did not really go down that list.
That is correct, Your Honor.
But the argument is the court got close enough and maybe not have been really articulate about breaking them down, but kind of said mostly the things the court needed to say. What do you think about that?
Well, Your Honor, the factors are not to be held within a vacuum. They're to be each reviewed by the court, the lower court, in their order when they're dismissing with prejudice. And so it's not just each factor individually standing on its own. It's all 6 factors collectively.
Didn't the trial court warn that if the depositions of the Walshes weren't taken, that dismissal was going to be in order? And between the time that that order was entered and the time that the dismissal was entered, there were no steps taken to get relief or ask for additional time. And so the judge sees in the court record that nothing's been done. And I know you call it sua sponte, but doesn't the court have the inherent power to enforce some orders when they're disobeyed?
Yes, they do, Your Honor, but to dismiss a case with prejudice is the ultimate sanction for what results to be a discovery violation. And Your Honor, it is our contention that our clients did in fact comply with that. Documents were sent over.
I understand, okay, but help me out. Between the time that that order was entered, and that's not just the first order on ordering the Walsh depositions, right? Let's be honest here. So there were a number of orders, and just to give a little flavor of what was going on, I think I wrote down a statement, like the court said something like, I've entered 5 orders for basic kindergarten stuff. So the court's obviously frustrated, right? So between the time that the order's entered, where the court warns of dismissal, the depositions aren't taken, can you tell me if there was record activity in the court record that would have given the court, oh, look, they're working on it?
There was not, Your Honor. There was, however, on the motion for a hearing, there was an attempt to provide that information.
Okay. And then that gets me to that order.
Yes, Your Honor.
Okay, and you know where I'm going with
I do.
this, because I can see the smile on your face, because there's a bunch of emails that the court sends to the attorneys, right?
That's correct.
And I don't see where these were responded to, which is another absence of information that the court is receiving. And I understand what you're saying, that yes, there is some sort of activity, there's some conflict about whether or not the records were produced to Mr. Yancey. I think there's a reference in an order, prior discovery order. The problem I have now is you get to the point where you kind of dug yourself in a hole and no one's responding to the court.
Yes, Your Honor, and I understand that point. However, even in their analysis, at the dismissal, that's at best reviewing one of the Cozell factors, whether the attorney's actions were willful and willful, deliberate, or contumacious. Difficult word there. And so the idea is, though, that they didn't, of the 6 Cozell factors, only 2 were really analyzed through the process of the case, whether it was the attorney's actions were willful and deliberate, and then whether or not the attorney had been previously sanctioned. We concede those. We concede that those 2 factors were in fact reviewed, but there are 4 other factors that were required to be reviewed.
And what if it were the party's actions? Would Cozell apply?
That's another factor of the Cozell. That's number 3. So then moving forward, the court simply had to have reviewed each one of the Cozell factors with the facts of the case at present.
Then wouldn't the appropriate relief here, I mean, assuming you're correct, assuming that the court inadequately addressed the Cozell factors, all of them as it was required to do before entering this kind of sanction, wouldn't this be appropriate to just simply reverse and remand for the court to make sufficient findings?
And Your Honor, that is one of the reliefs that we have sought in our brief.
But the way I read it is that you all were asking us to reverse it and allow the parties to complete discovery and present their issues at trial. So I gathered from that you were saying, this is water under the bridge, we move on.
Your Honor, I do think that there is valuable discovery to be completed, and I do think that in fact that there is more to be decided. This is
Unfortunately, there's been a clear demonstration that the parties aren't up to that.
well, Your Honor,
That's why we're here, right?
but again, our position is that in fact that we provided the documents and that our client was present during those 60 days within the state of Florida. Massachusetts resident flew down, resided in the state for the 60 days, waiting for the deposition to occur.
That was another matter.
That came off, no, that was for the deposition based upon the March 26th order denying the protective order. After that order, my client flew down and made himself available.
And there's some issues about whether or not records were, and that's where all the record issue comes up.
That is correct, but at the same time, Mr. Yancey was not then represented by counsel, but we had provided
What
documents.
is the first response after the dismissal order is entered? What motion do y'all file?
On that one, we filed the motion for reconsideration. Or, I'm sorry, we filed the motion for rehearing.
Did you file a motion for relief?
No, I don't believe we did. We did. And so, Your Honor, where we stand here is that we have an order that highlights 2 of the 6 Cozell factors, and Florida law is pretty clear that all 6 need to be analyzed and then articulated in writing, and especially in a situation where we were not even allowed to present our argument in the matter.
So is it reversible per se if the Cozell factors are not analyzed and found by the court?
Looking at the,
Do you have something that tells us that? Per se reversible?
I don't have anything per se, but I do have copious amounts of case law that does in fact articulate that once these 6 factors are not articulated, they're not reviewed.
Well, here's the thing, Cozell was decided in 1993. We were still fairly civil at that time. This bad behaving lawyers and clients,
We're happy days.
we're spending lots of time on these cases these days.
Yes.
There's more than just this one on the docket today. So maybe it's time to look at this and make it more streamlined.
Well, Your Honor, even still, and streamlining the 6 Cozell factors would be fine, but at least having an order that articulates how the facts of the case apply or are analyzed through the Cozell factors would at least allow future parties to know exactly where they're moving forward. Here, we're at a loss. We have 2 of the 6 Cozell factors reviewed. We feel that we had a cogent argument as to why, in fact, that was not complied with, right? One of the Cozell factors.
But the court gave y'all an opportunity, and there wasn't a response to the communication from the court saying, hey, help me out here. And it almost looked to me that the trial court was, hey, if you gave me the information, then I would reconsider.
I think, Your Honor, there's an interpretation within the giving of that
So
can
did
be.
you guys just say, oh, well, I know what your decision's going to be, so I'm not going to bother to respond?
No, Your Honor, we were in belief that we complied. We provided a link to the Dropbox. The size of the documents that we were attempting to provide to the lower court was too large to send by email. And so we provided a link to a Dropbox, to which the court then stated it was too many and too great. And they weren't able to figure out exactly which documents were from pages 2 and 3 of the order.
And that came in early August, okay? And then after, it's on August 18th, the court again asked to provide a status. And then on September 13th, the court asked for another status. And then the order was in October, and 3 months had passed, and no status. So correct me if I'm wrong, was there a status between August 18 and the entry of the order?
There was nothing on the court record, Your Honor, and I can't speak to beyond that. What I can speak to is that, again, the order, the documents were provided to the court in the broad sense of the word delivery. And then they were also provided to Mr. Yancey, both to his prior counsel and to Mr. Yancey himself, we were under the belief that we had complied with the court's order.
But I guess if I see an order that says, hey, my client's depositions have to be taken by X date, otherwise I'm going to dismiss the case. I don't know, I think I take that really seriously, and if I'm worried about the dismissal, then I go seek relief and ask, hey, this is the issue. But we don't have any of that.
No, Your Honor, but we were in fact, again, we were in communication with Mr. Yancey. We did explain to him that our client was present in Florida and was prepared for that. And again, this is one of the 6 factors and not any of the other 5. And so just one of the factors is not sufficient enough to dismiss the case with prejudice, according to the law of Florida. When we look at it, and had we had an opportunity to articulate our side or the excuses as to it, that would have provided more substance to the violations as articulated. But this is a 9-year-old case, and there were orders for contempt and motions to compel going back and forth throughout the entire process of this litigation.
So it's really not hard to blame Judge Huey for finally saying, I've had it.
It's not, Your Honor, and you can tell that there was absolute frustration at the parties in the lower matter, but I don't think that, again, we stand on the law that dismissal with prejudice being the ultimate sanction for discovery violations. I do think that this went too far, and so again, we ask that this court reverses that decision, quashes it. And with no further questions, I will yield my time.
Okay. You'll have 5 minutes when you come back.
Thank you.
Good morning, Your Honors. If it pleases the court, my name is Charles Yancey, representing myself pro se in this matter.
So, Mr. Yancey, if you don't mind, let me just ask the question. We do have the Supreme Court decision, Cosell versus Ostendorf, that basically says the court must specifically articulate its review of the 6 factors and make findings. And it's abundantly clear in this case that did not happen. Okay, that being the case, we're probably compelled to reverse it, but I want to hear what you think about that.
This case went on for 9 years. The lower court was patient. I was patient. I had an attorney Economides, in the beginning. I could no longer afford him, so I had to represent myself. It went on and on. The law firm actually had 9 lawyers on this case. This is the 10th one. And they kept adding a new lawyer every year. And they asked the judge, we got to get up to speed on this case, so we need more time. In the meantime, the court was very patient, requested these documents, ordered these documents multiple times from John Walsh III, Chesterton Capital. And they wouldn't submit them. And he gave them so much opportunity, again, 9 years worth, and they didn't comply. I personally believe that the appellant, plaintiff and counter defendant would never allow himself to be deposed, ever. So it wasn't.
The attorneys in this case that were sanctioned on the other side.
I don't know that the attorneys on the other opposing attorneys were sanctioned. I don't.
Certainly there were orders of contempt that were entered.
Yes, but they were against the parties. Multiple orders of contempt of court, failure to comply with the court orders, failure to respect the court's orders. And I think the court gave them multiple times. I know the court gave multiple times to submit these documents, finally gave them the last 60-day period, and we never got anything. Nothing was ever filed with the court. Nothing was ever sent to me. I'd ask the law firm, well, if you have copies of them, send them to me and file them with the court. Don't, say, oh, some Dropbox technical thing happened. You've got paper documents. Go run them down to the courthouse and file them. Send a copy to me. I'll go pick them up. Where are these documents? They never had them. John Walsh never produced the documents that were ordered by the court. So if there's
The
any
law is
questions,
frustrating, Paul, I can hear it in your voice and I understand.
thank you.
Problem is, we have the law we have to follow.
I understand.
Whether we like it or not. And as I tell people all the time, many times, we have to hold our nose to sign an opinion because the law requires it, even though we think it should be some other way.
I understand, Your
I
Honor.
understand.
I do, thank you.
You have 5 minutes, sir.
Thank you, Your Honor. Your Honor. What I'd like to point out is just simply that there are lesser sanctionable, lesser sanctions that can be applied to this matter other than the dismissal.
9 years pending with all these shenanigans, dismissal, it screams dismissal.
Yes, Your Honor.
Okay, it screams dismissal.
But
The
there
only
was-
question is whether the law was complied with in dismissing it. That's the only question.
Your Honor, yes, Your Honor. And again, the law was not complied with. The lower court did not review all 6 Cozell factors. The law,
In our case, in our court's case of Valor v. Bank of America, we reversed for that reason. We said that the trial court failed to articulate the causal factors. We remanded for the trial court to consider the causal factors and enter an appropriate order. Why would that be an inappropriate remand direction in this case?
it wouldn't, Your Honor, but I also think that the court would be hard pressed to apply all 6 factors to the case at hand. And while that might go into the merits of the lower court's decision
We're
at
not
this,
supposed to do, I mean, right?
right.
Okay.
But I do think that the lower court would be hard pressed to apply these 6 factors to the case at hand, especially in light of the 9 years of vexatious litigation that has occurred throughout this process. And so looking to, there's,
Well, I mean, I guess entertaining, I guess the question is whether when we send it back, if the court's required to make a finding as to each and every 6 of the factors and weighing that, what would the appropriate sanction be?
and that is,
And it may be right back where we were, right? Or it may not, I don't know.
yes, Your Honor. And the court in Ham versus Dunmire, or the Supreme Court in Ham versus Dunmire reviewed this for that exact reason. And they're concluding it was the abuse of discretion where the trial court fails to make written express findings supporting a conclusion of failure to obey the Cozell Act, obey the court order, again, demonstrating willful and deliberate on the attorney's end. 1 of 6 factors have been reviewed. Maybe at best 2 of 6 factors have been reviewed by the lower court in their orders.
Well, we don't know what was reviewed. And their findings aren't here, but we don't know what the court reviewed because it's enters the sponte. Right?
Well, Your Honor, the court had an opportunity in their order to articulate their facts as required by,
I agree, but we don't know what the court reviewed before it entered the order.
no, Your Honor, we don't, but we are stuck with and filling in the gaps in
The order
between.
lacks, I would agree with you.
And so with that, Your Honor, I would ask that this court quash the order of dismissal and remand for further proceedings. Thank you. Thank you.
Not a pleasant case, but you both did a great job. I appreciate it.
Thank you.
Our next case is Zelensky Tax Advisor versus Department Tax Advisor. And there are other people involved on this.